Okay, can you see that, everybody? I hope so. So what I wanted to make very clear is that the FIDIC subcontracts are specifically drafted for a specific FIDIC main contract. And so you'll see here, and I'll use my mouse, you'll see here that the Red Book Construction Subcontract is drafted specifically for the Red Book 1999 and not the FIDIC Red Book 2017. So if you don't come away with anything else today other than that note, then I'll have done a reasonably good job. And it has a similar type of structure and format with 20 clauses and guidance notes for the drafting of particular conditions. Now, one of the things I know that in the Southeast Asia and in Vietnam itself, and also the Middle East, the FIDIC MDB harmonized edition, which is used by the development banks, that's used quite extensively still, which is a version of the 1999 Red Book. And there's the 2005 version or the 2010 version. And what I would say is that the FIDIC construction subcontract can only be used with this, what we call the pink book, if there are necessary amendments made. And what will need to be done is that this pink book, the MDB harmonized edition, is compared with the Red Book, the original Red Book 1999, and the same changes then made to the subcontract if it is to be directly back to back. And I would also say that the FIDIC construction subcontract is not suitable for use for nominated subcontracts, unless it is amended by particular conditions, and that those particular conditions make the necessary reference to the specific terms of the main contract that deal with nominated subcontractors, pardon me. And just going back to Chow's presentation, which was very good and very interesting, I'd just like to point out that, or clarify something that might be different in Southeast Asia than it is in Europe. We use the word nominated subcontract, and it's used in FIDIC contracts to mean a contractor that the employer tells the main contractor he has to actually engage and appoint. But the word named subcontractor is generally used to describe the subcontractors that the contractor, the main contractor, names in his tender, which is then accepted to become the main contract. So just that little distinction between different parts of the world, just hopefully it won't cause confusion. Now, the FIDIC design-build form of subcontract, and similarly, it's been specifically drafted for the FIDIC Plant and Design-Build Yellow Book 1999, not the FIDIC Yellow Book 2017. And there's a Latin term you will have seen on my first slide, mutatis mutandi, and that just means that they both need to be read side by side. So you have to have the Yellow Book 1999 and the design-build subcontract in front of you to be able to completely understand exactly what is meant by the subcontract. And the meaning of that is that the subcontract is not a standalone document. And that also applies to the Red Book subcontracts, the construction subcontract. So you might just keep that in mind. Now, when we talk about the design-build form of subcontract, we can say that there are three different types of subcontracts that the main contractor might want to let out. It might be a design build of part of the works, because the main contractor is required to design and build the whole of the work. So he might want to subcontract only part of that design and build. And in that case, then the Yellow Book subcontract, the Yellow Book subcontract is perfect. But if the main contractor just wants to subcontract the design of parts of or the whole of the main works, then the contractor might consider using the FIDIC White Book, the Client Consultant Model Services form of agreement. But if the main contractor just wants the subcontract to build what the main contractor has already designed, then the main contractor might consider using the FIDIC Construction Subcontract, even though that hasn't been drafted for the Yellow Book 1999. And in the cases where the White Book, the Client Consultant Model Form Agreement, or the Construction Subcontract are going to be used for a Yellow Book 1999 main contract, then it's very important that the differences are fed down through that subcontract so that the subcontracts remain back to back. So Chow referred to the phrase back to back, and I've just taken a quotation there of what it might mean. Two contracts, two agreements that are linked, and which all of the liabilities, obligations, but also the rights as well, are mirrored from one agreement to the other. And for FIDIC subcontracts, the reason why they have to be read side by side is that each of the subcontracts incorporates by reference, only by reference, the terms of the corresponding 1999 FIDIC contract. So that means that the construction subcontract has to be read alongside the 1999 Red Book. The Design-Build subcontract has to be read alongside the 1999 Yellow Book. Now, for those of you who might find yourselves in the position of requiring a subcontract to the Silver Book 1999, that's the EPC turnkey form of contract, or subcontracts to the newer 2017 main contracts, the Red Book, the Yellow Book, and the Silver Book, then I can tell you that the FIDIC at the moment has started to prepare those subcontracts, but it'll probably be a number of years, a couple of years, before those subcontracts will be ready for publication. And the important thing to remember is when we say back to back is that each FIDIC subcontract passes down to the subcontractor similar or identical terms to those of the main contract, but different to other subcontracts, particularly subcontracts that main contractors themselves have drafted. It's both the obligations and the rights that are passed down. And you'll see that if you look at FIDIC subcontracting subclause 2.2 and 2.3. So Chow also made the point, and I'd like to reiterate it, that the subcontract is a separate contract between the contractor and subcontractor, but it can't exist independently of the main contract. I think Chow said under the Vietnam Civil Code, but that would apply also for all of the FIDIC subcontracts, that the validity of the subcontractor depends on the main contract. It's just a different way of saying the same thing. Now, so we're making it back to back. So the contractor then is under an obligation to make all of the documents of the main contract available to the subcontractor for inspection, except the prices and except what might be actually expressly designated as confidential parts. Because if you're going to make the subcontractor require them to actually take on the obligations, then the subcontractor needs to know what those are. And so there's specific, you'll see there 3 documents that the contractor is specifically required to provide: the appendix to tender of the main contract, a copy of the particular conditions of the main contract, and any other contractual provisions. And once that information has been provided, then the subcontract states that the subcontractor shall be deemed to have full knowledge of the relevant provisions of the main contract. And what are the relevant provisions? Well, those are the provisions that apply directly to the subcontract works. And I've just quoted there from subclause 2.2 and subclause 2.4 that refer to the back-to-back obligations transfer and the back-to-back rights transfer. But you'll have a copy of these slides so you can look at those yourself. And then we move on to, well, what happens if the subcontractor actually causes a breach of the subcontract? And subclause 2.2, the last paragraph, said that the subcontractor will then indemnify the contractor against the damages that might flow up to the main contract, where the main contractor becomes liable to the employer. So that indemnification is very important for subcontractors to realise. And then the contractor can recover damages that he mightn't otherwise be able to recover from the employer. He can recover those from the subcontractor because it was the subcontractor that caused the breach. Now, Chow very helpfully referred to pay when paid provisions, and those are reflected under subclause 14.6 of the FIDIC subcontracts, but only in respect of interim payments. So the idea is that the subcontractor submits a monthly statement to the contractor. In the next monthly statement to the engineer under the main contract, the contractor is obliged to actually put in whatever the subcontractor has applied for in that. And then the contractor then has 70 days to pay the subcontractor in respect of that monthly statement. Now, why such a long period of time? Well, that's basically the the employer has 56 days to pay the main contractor, and then there's an additional 14 days for the main contractor to pay the subcontractor. But, and this might be different from what applies in Vietnam, this contractor has the right to withhold payment to the subcontractor if the amount in the subcontractor statement hasn't been certified by the engineer under the main contract. But there is a proviso, and that proviso is that non-certification is not something to do with the main contractor's default. And the main contractor can also withhold payment or defer paying the subcontractor if the amount has been certified, but it hasn't actually been paid by the employer. And that's the pay when paid side of things as regards interim payments. But the FIDIC subcontracts then say for the final subcontract payment, that's right at the end of the subcontract works, when all of the works have been completed and the main contractor is now making one final payment to the subcontract, the main contractor has to pay the subcontractor, no matter whether the employer has paid the main contractor for the subcontract works. So what we say then is that the FIDIC subcontracts have provisions that are pay when paid, but not pay if paid. And I hope that I've been able to explain that distinction there. And Chow also very helpfully pointed out that in many common law countries, pay when paid provisions aren't actually enforceable. And so in that case, in the guidance notes to the FIDIC subcontracts, you'll see an example provision that can be used instead. Now, just for variations, I'm going to very quickly go through this because I don't want to run over time. Variations under subcontracts cause quite a lot of difficulties and quite a lot of disputes. So how has FIDIC tried to draft the subcontract to avoid the same sort of disputes? Well, it specifically says that the subcontract works can only be varied if the contractor makes a formal instruction, a written instruction. So if the engineer is going around doing an inspection and the engineer issues an instruction verbally or in written form directly to the subcontractor, that is not a variation under the subcontract unless it is confirmed or notified by the main contractor to the subcontractor as a contractor's instruction. And the contractor can issue an instruction for a variation at any time prior to the date of the taking over certificate that is issued by the engineer. Now, so that's the taking over certificate of the whole of the works issued by the engineer. And so the subcontractor might find that he has finished all of his works, he's gone away, and he still has to come back to carry out varied works because the taking over certificate for the whole of the works hasn't been issued by the engineer, which is somewhat similar to the case for mediation that Chow was talking about. So what's the scenario then if the engineer issues a variation under the main contract and it affects the subcontract works? Well, the contractor must issue a subcontract variation. The engineer then values that variation under the main contract. The contractor then values the subcontract variation, but then the subcontractor has to wait for payment for that variation, the subcontract variation, until the contractor has been paid for the variation under the main contract. And the reason for that is this pay when paid provisions. Again, for the common law countries where pay when paid provisions aren't enforceable, then you can look at the guidance notes to see an example change to that subclause 13.3. Sorry, 13.3, yeah, is the evaluation of variations. So, sorry, pardon me, go back if I can. There we go. So I spoke about taking over there, and there are two options for taking over under the FIDIC subcontracts. One is the subcontract works are only taken over when the whole of the works are taken over under the main contract, and that's what's stated in subclause 10.2 of the subcontract, both the design-build form of subcontract and the construction form of subcontract, the red book subcontract and the yellow book subcontract. And so that means that the subcontractor remains obliged to stay with the project until such time as the contractor is relieved of his obligations by the employer through the engineer issuing a taking over certificate. But the second option is probably one that might apply more often than not, and that is where the subcontractor finishes his works quite early in the project. And the contractor doesn't need that subcontractor to stay on board until the taking over certificate is issued. For example, if it's a pilings works, foundation works subcontract. In that case, then the early taking over by the contractor before the employer takes over the whole of the main works must be set out in Annex C to the subcontract. And that provision there is stated in subclause 10.3 of the subcontracts, both the FIDIC subcontracts, both the yellow book subcontract and the red book subcontract. And now just talking about subcontractors' claims. Now, there is a requirement under the FIDIC subcontracts for the subcontractor to make his claim against the main contract within 21 days to give that notice of claim. And if that notice isn't given within 21 days, so it's given outside that period of time, then the subcontractor loses his entitlement to the claim itself. And the English version word for that is time barred. The contractor then might want to pass that subcontractor's claim up to the employer under the main contract. And the main contractor then has another 7 days to do that, to give a notice of claim to the engineer, because the time period under the FIDIC Red Book and the FIDIC Yellow Book 1999 is 28 days. And the reason for that is this idea of the subcontract being back to back with the main contract. The subcontractor then has to submit a fully detailed claim, and the time period is there. And if the subcontractor has passed up the same claim under the main contract, then the contractor then has just an additional period of time to prepare the detailed particulars. And I just want to warn you again that if the subcontractor breaches these claim provisions and the main contractor loses out by not being able to submit a notice of claim under the main contract to the engineer, then the subcontractor indemnifies the main contractor for any damages or any losses that might be incurred in that way. But there are three options, because subcontracts on projects come in all different shapes and sizes and complexities. So clause 20 of the general conditions is what we call the middle ground for subcontracts of mid-range complexity, where it is probable that, if there is a dispute, that it'll be related to disputes under the main contract. Pardon me, I'm just talking about disputes here. I said claims there a minute ago, I'm sorry. So under subclause 20.4, the subcontractor raises a dispute, gives a notice of dissatisfaction. The contractor can then notify the subcontractor that the subcontract dispute is related to a dispute under the main contract. And then the contractor has this magic period of 112 days during which the subcontractor has to wait and do nothing. And in that period of time, the contractor then proceeds with getting a decision on the dispute under the main contract. And that's the reason why there's that period of 112 days. Now, the important thing to remember for this option one is that the main contractor's DAB's decision is not binding on the subcontractor at all. And after that 112 days has expired, the subcontractor then has options. He can either refer the dispute to a subcontract DAB, different one to the main contract DAB, or directly to arbitration, because he's already waited a period of time and he might not want to go through the DAB process. He might want to go directly to arbitration. But the contractor, if the contractor wants to refer the dispute, he can only refer to the subcontract DAB. The second option then is what's called the first alternative in the guidance notes. You might have a look at that. And that's very simple. That's just all subcontract disputes go straight to arbitration. And then there's a second alternative in the guidance notes, which is very complex. And that means that claims and disputes can be related or unrelated. And I have a few more minutes to talk about what that might mean. But when decisions are made, when the determination of the claim is made by the engineer under the main contract, a DAB decision is made under the main contract, or an arbitral award, and arbitrators make an award under the main contract, those are binding on the subcontract. So I'd just like to refer you to the flow charts at the front of the FIDIC subcontracts for a little bit more information on that. It's a little bit clearer there, exactly what's meant. And just before I finish, to run down very quickly about what the second alternative is, because this is where the multi-party dispute resolution comes in under FIDIC contracts, is by way of this provision, this second alternative in the guidance notes of the subcontracts, because the published documents, FIDIC documents, don't talk about multi-party dispute resolution. So this is the only place that you'll see it, is this second alternative in the guidance notes. So the claims, so the contractor can decide whether the claim is related or unrelated to a claim under the main contract. But if the subcontractor doesn't agree with that, because he doesn't want to wait and he doesn't want to have to rely on the engineer to make a determination, he can object. And then there's a pre-arbitral referee that's under the ICC rules will apply there. But if it's an unrelated claim, so the contractor isn't going to be interested in referring this up to the main contractor under the main contract to the engineer, then that claim is just determined by the main contractor. But if it is a related claim, the subcontractor will only get a share of the benefit that the contractor will get under a determination by the engineer. And then this second alternative also deals with disputes that can be related or unrelated. And the idea is that a related dispute will have come from a related claim. An unrelated dispute will come from an unrelated claim. And if there's a dispute that doesn't arise from a related claim or an unrelated claim in any way, shape or form, which would be quite unusual, can happen, then the contractor can decide whether it is a related or an unrelated dispute. So for an unrelated dispute, it's fairly straightforward. It's to be decided by a subcontract DAB, and that's an ad hoc DAB that's just appointed when a subcontract dispute arises, and only for that dispute. But if it's a related dispute, then the subcontractor is only entitled to a share of the benefit that the contractor receives, as decided by the main contract DAB or the main contract arbitrators. And so in that way, then the main contract DAB's decision or the arbitral award is binding on the subcontractor. But if the contractor is deciding the share to be given to the subcontractor, and if the subcontractor is not satisfied with that share, then that becomes a dispute in itself, and then the share is just decided as or dealt with as an unrelated dispute by the subcontract DAB. Now, I know that's a lot of information, and I hope I haven't confused you, but I would encourage you to have a look at the guidance notes of the two forms of FIDIC subcontracts and also the flowcharts. And thank you very much for your